These are the 11,527 wheelchairs and scooters that American Airlines damaged, delayed, or lost in a single year, 31 per day, every day. And for decades, passengers had almost no legal way to fight back. Then, the U.S. government finalized the strongest wheelchair protection rule in the history of commercial aviation. It took effect on January 16, 2025. And 4 days later, the administration changed, and the rule's most important protections were quietly put on hold. This is what happened, why it matters, and what it means for anyone who flies with a wheelchair. To understand why this rule was such a big deal, you have to go back to 1986, when President Reagan signed the Air Carrier Access Act into law. That legislation, known as the ACAA, prohibits airlines from discriminating against passengers on the basis of disability. And it came with a set of rules that looked, on paper, like genuine protection. Airlines cannot charge you to check a wheelchair. They must assist you boarding and deplaning. And if they damage your chair, they are supposed to cover the full cost of repair or replacement. Reasonable protections, all of them, and the kind most travelers assume, have real teeth behind them. Here is where it falls apart. Unlike virtually every other civil rights law on the books, the ACAA gives passengers no right to sue an airline directly, and courts have confirmed this repeatedly. Destroy someone's $30,000 custom power wheelchair, and they cannot take you to court over it. They file a complaint with the Department of Transportation and wait. Kelly Buckland, a quadriplegic wheelchair user who served as DOT's disability policy advisor under the Biden administration, described the situation in terms that are hard to argue with. You cannot sue an airline for any of this. You're entirely dependent on the Department of Transportation. And that dependence, across nearly 4 decades, produced very little. No requirement existed for annual hands-on training for the workers who physically move wheelchairs through cargo. No rule required airlines to notify passengers that their chair had been unloaded before they left the plane. No deadline existed for returning a delayed wheelchair. No airline was required to publish whether a wheelchair would even fit in the cargo hold of the aircraft a passenger had booked. None of that mattered because the most damaging gap of all was the burden of proof. When a wheelchair came back from the cargo hold damaged, the passenger had to prove the airline did it, and the airline simply had to deny it. That arrangement held for nearly 40 years, and the results were exactly what you would expect. Wheelchair mishandling statistics only started appearing publicly after 2018, when Congress required airlines to report them as part of the FAA Reauthorization Act, and what those numbers revealed stopped a lot of people cold. In 2023 alone, U.S. airlines mishandled 11,527 wheelchairs and scooters, a rate of 1.38% of all devices checked, which runs roughly 3.5 times higher than the general checked baggage mishandling rate. Bags go missing at about 0.4%. Wheelchairs get damaged, delayed, or lost at 1.38%. And these are self-reported figures that airlines submit about themselves. Disability complaints filed with the DOT jumped 28% in a single year, climbing from 2,098 in 2022 to 2,685 in 2023, and advocates describe even those numbers as a massive undercount, because most passengers never file. The dollar consequences can be severe in ways that the standard baggage liability cap never accounted for. The average power wheelchair runs around $7,000, while custom rehab chairs, built specifically for a person's spinal cord injury, their muscle disease, their pressure sore history, land between $10,000 and $30,000. Before this rule, airline liability for a damaged wheelchair was often capped near $3,800 for domestic flights, which meant an airline could destroy a chair worth 10 times that amount and owe less than a used car. Senator Tammy Duckworth of Illinois, a double amputee, wheelchair user, and combat veteran, frames the scale of this problem in a way that lands differently than a percentage point. Her own wheelchair gets damaged roughly every 3rd flight, and her comparison is direct. When an airline damages or breaks a wheelchair, it's the equivalent of breaking someone's legs. Then she adds, imagine if the American public saw that the airlines broke 892 pairs of legs in a single month. There would be hue and cry. American Airlines alone collected 9,717 disability-related complaints directly from passengers in 2023, which is a remarkable internal number for a single carrier in a single year. No single story captures what is actually at stake here more clearly than what happened to Ingracia Figueroa and the way it ended. On July 14, 2021, Figueroa, a well-known disability rights activist, flew from Washington, D.C. to Los Angeles on United Airlines, returning from a rally called #CareIsEssential. The cargo hold destroyed her custom power wheelchair, the one built for her body, valued at $30,000. Stranded at the airport for roughly 5 hours while the airline sorted out next steps, she was eventually given a replacement that didn't fit her needs. United initially refused to provide a proper loaner and pushed for repair only, and that ill-fitting substitute caused a pressure sore that became infected and spread to her hip bone. Emergency surgery followed. Ingracia Figueroa died on October 31, 2021, at 51 years old, from complications of a condition that started with an airline destroying her wheelchair. Her words spoken before she died are still repeated by advocates. Mobility devices are an extension of our bodies. When they are damaged or destroyed, we become redisabled. The Paralyzed Veterans of America filed a formal petition for rulemaking with the Department of Transportation in December 2022, and that petition cited her case directly. 2 years of public comment periods, formal review, and nearly 2,000 submitted comments later, Secretary Pete Buttigieg signed the final rule on December 12, 2024, and it was described by the DOT as the most protective wheelchair accommodation rule ever issued in global commercial aviation. Published in the Federal Register on December 17, 2024, the rule carried a formal title, Ensuring Safe Accommodations for Air Travelers with Disabilities Using Wheelchairs, and a set of specific requirements that represented the first major rewrite of wheelchair protections in roughly 16 years. For the first time in the law's history, safe and dignified assistance received a formal definition. Safe assistance meant assistance that does not put passengers at heightened risk of bodily injury, including through wheelchair damage. Dignified assistance meant assistance that respects a passenger's independence, autonomy, and privacy. Not a vague aspiration, but a regulatory standard with a penalty attached. The biggest shift was the rebuttable presumption of airline liability, which reversed the burden of proof that had shielded carriers for decades. Under this provision, if an airline returned a wheelchair damaged, the airline was automatically presumed to be at fault and had to prove otherwise, rather than the passenger having to prove the airline did it. Violations carried penalties of up to $124,000 per incident. Airlines also face new notification requirements, including a mandate to tell passengers, before they left the plane, that their wheelchair had actually been unloaded, and a requirement to provide written notice of passenger rights anytime a mishandling occurred. Delayed wheelchairs on domestic routes had to be returned within 24 hours. Airlines had to pay for loaner wheelchairs after any mishandling, consulting with the passenger on matching that loaner to their functional and safety needs. Ground transportation costs caused by a delayed device had to be reimbursed. And if a wheelchair didn't fit on a booked flight and the passenger had to buy a more expensive ticket, the airline was on the hook for the fare difference. Annual hands-on training for all employees and contractors who handle wheelchairs or assist passengers with mobility disabilities became mandatory, with competency assessments required and refresher training due every 12 months. All current personnel had until June 17, 2026 to complete it. The rule took effect January 16, 2025, and 4 days later, the political ground shifted entirely. January 20th, 2025 brought a new president and a memorandum directing all federal agencies to freeze pending rules, pending review, and the DOT moved quickly to implement that directive. Sean Duffy, confirmed as Transportation Secretary on January 28th, issued department-wide orders consistent with the freeze. February 14th is when it got worse. Airlines for America, the industry's primary trade group, filed a lawsuit in the Fifth Circuit Court of Appeals, and American Delta, JetBlue, Southwest, and United Airlines all joined the challenge. 5 of the largest carriers in the country were in federal court, arguing that a rule designed to protect wheelchair users exceeded the government's legal authority. Their central claim held that the ACAA's prohibition on discrimination does not authorize automatic liability for wheelchair damage, and that circumstances outside an airline's control, turbulence, pre-existing damage, should not be treated as civil rights violations. 6 days after that lawsuit landed, on February 20th, the DOT published its first enforcement discretion notice. The government would not enforce the wheelchair rule at all until March 20th, 2025. That deadline was extended again in June and extended once more in September. By September 30th, 2025, the DOT had settled on a more targeted approach. Most provisions would be enforced, but 4 specific ones would remain untouched until at least December 31st, 2026, and a new rulemaking called Wheelchair. Rule 2 was announced that could permanently rewrite or eliminate them. The 4 frozen provisions are worth naming directly. First, the rebuttable presumption of airline liability, the requirement that carriers prove they didn't damage a wheelchair, not the other way around. Second, the annual training frequency requirement. Third, the pre-departure written notification of passenger rights. Fourth, fare difference reimbursements when a wheelchair doesn't fit on a booked flight. The rule technically remains in effect, but the DOT is choosing not to penalize airlines for ignoring these 4 provisions. And the practical difference between that and not having the rule at all is difficult to articulate to a passenger whose chair comes back in pieces. Aviation law firm Steptoe LLP reviewed the situation and reached a conclusion they put plainly. It seems most likely that none of the pause provisions will remain in place. Airlines for America has maintained publicly that U.S. carriers are committed to providing safe, inclusive travel for passengers with disabilities, and their legal argument against the rule centers on the question of what the ACAA actually authorizes. A rebuttable presumption of liability, they argue, creates something close to automatic fault, and that goes beyond what a statute prohibiting discrimination is allowed to impose. Circumstances beyond airline control, they say, should not automatically become civil rights violations. Costs entered the conversation as well. The DOT's own regulatory impact assessment estimated that the training requirements alone would run the industry $292.7 million over 20 years. American Airlines, which the DOT fined $50 million in October 2024, a penalty 25 times larger than any previous disability fine in aviation history, stated publicly that it had invested $175 million in disability services in 2024 alone. The airline's wheelchair mishandling rate dropped from 2.01% in 2022 to 1.41% through the first 3 quarters of 2025, which the industry has pointed to as evidence that voluntary improvement is happening. What also happened in May 2025, though, is that Airlines for America sent a 93-page request to the DOT asking for the removal of multiple consumer protections across the board, not just the wheelchair provisions. The DOT's spring 2025 regulatory agenda classified 119 of its 133 newly announced rulemaking actions as deregulatory, and Wheelchair Rule 2 appeared on that list. The disability community's response has ranged from angry to furious, and the people speaking out are not doing so abstractly. Heather Ansley of the Paralyzed Veterans of America put the organization's position directly. We believe that any efforts to decrease its protections or delay enforcement of any of the rule's provisions only prolongs the risks wheelchair users face every time they fly. John Morris, whose wheelchairtravel.org has documented airline wheelchair damage for years, and whose own chair has been written off as a total loss 4 times, addressed the airline lobby without much patience. Don't gaslight me. Don't tell me you're committed to removing barriers to safe and accessible air travel, while simultaneously fighting to block common sense regulations that are a response to repeated Air Carrier Access Act violations. Samantha Jade Duran, a wheelchair user who worked alongside the Buttigieg DOT on developing the rule and watched the lawsuit land 3 weeks after it took effect, chose words that reflected what that timing felt like. Airlines have disregarded our mobility aids, spoken about our disabilities like they're a burden, and put profits over our basic safety. The Center for American Progress included the wheelchair rule delay in a July 2025 report titled "The Trump Administration's War on Disability," and in February 2026, the National Center for Public Policy Research, a conservative-leaning organization, called on the administration to reinstate the rule immediately. The Muscular Dystrophy Association submitted over 400 comments during the rulemaking process and sent advocates to meet directly with the DOT's acting general counsel in September 2025. 5.5 million Americans use wheelchairs. Roughly 27 million Americans with various disabilities flew in 2019. And Corey Lee, an accessible travel blogger whose 400-pound wheelchair gets damaged on roughly half his flights. Put the broader point simply, air travel is what needs the most help in the travel industry to become more inclusive and accessible. Most of the DOT wheelchair rule remains technically in effect and is being enforced as of early 2026. Airlines are required to provide safe and dignified assistance, cover the full cost of repairing or replacing damaged devices, supply loaner wheelchairs after any mishandling, and return delayed chairs within 24 hours on domestic routes. None of that changes the fact that the 4 frozen provisions, the ones disability advocates describe as the rule's enforcement backbone, are sitting idle. The rebuttable presumption of liability, the single mechanism that reversed 40 years of burden of proof imbalance, remains unenforceable. When a wheelchair comes back from the cargo hold with the joystick ripped off, the frame bent, and the electronics dead, the passenger still carries the weight of proving the airline did it. And that is the same position wheelchair users have been in since 1986. The airline lawsuit in the Fifth Circuit remains held in abeyance, paused, not dismissed, and can be reactivated at any time. Worth noting about that court, it struck down a separate Biden-era DOT consumer protection rule in January 2025. Wheelchair. Rule 2, the new rulemaking that could permanently rewrite the frozen provisions, is not expected to produce a proposed rule until August 2026 at the earliest, with a final rule following sometime after that. Across nearly 4 decades, 31 wheelchairs are still being mishandled every single day. This is not a story about whether airlines are well-run or poorly run. What it comes down to is accountability. Specifically, who carries the burden of the proof when a $25,000 custom wheelchair comes back destroyed, and a passenger who depends on that chair for every basic function of daily life is left sitting without it. For nearly 40 years, the law said, you cannot sue an airline for this. All you can do is file a complaint and wait. The 2024 rule tried to shift that balance, not by letting passengers sue, but by requiring airlines to explain themselves when something went wrong, by setting explicit timelines, by requiring real hands-on training, and by reversing the burden of the proof that had protected carriers at the expense of passengers for 4 decades. The rule's most powerful protections lasted in practical terms a matter of weeks before the freeze arrived. Whether you use a wheelchair or not, the question this story leaves behind is worth considering. When a rule protecting 5.5 million Americans can be suspended through enforcement discretion, held in court by the airlines it was designed to regulate, and handed off to a new rulemaking classified as deregulatory, what does airline accountability actually look like? Kelly Buckland, who has used a wheelchair since he was 16, offered his assessment before leaving the DOT. Air travel for people with disabilities hasn't gotten much better for decades. In some ways, it's gotten worse. The rule was supposed to be the answer. Whether any version of it survives depends entirely on what comes next.